Welcome back to College Football Addiction, the sport that we love and know. College football is changing, and we even got some news this week about a new act along with the House settlement that we're going to talk about with Paul Aloise Jr. of Ruben and Ruben Law. Paul, I appreciate you for joining us. Man, it is, you played football, 10, 11, 12 years ago, somewhere in there, and did you ever think it would get here? I mean, before we really dive into all this, you could kind of feel like the winds were changing, or like right when you finished playing was when the football game went away we were just talking about O'Bannon and stuff. So it felt like the winds of time were changing, but did you ever think we would get here?
I didn't actually think we would get here. And just to step back, thank you for having me, of course. It's a great Friday. College football is almost here. Always a pleasure to see you, TJ. So thank you for having me. But no, I never thought we'd actually end up here. I mean, I wanted us to get to a version of this. I was hoping we'd get to a version of this. And I think you and I have talked about it before. One of the first times I recall hearing NIL coming into massive front page news in the sports world was when the Red Sox almost signed traded for Alex Rodriguez, right, in 2003. And ultimately, the MLB came in, put the kibosh on that, and he ended up in New York. But a big reason for that was the Red Sox were trying to offset some portion of his salary by allowing A-Rod to basically have control over his NIL and be able to profit off of it. And so that was something that I was like, wow, you know what? If they could take that into college sports, that might be a way to work around the amateurism, status that the NCAA and the schools want these student athletes to maintain, but also give these student athletes an ability to go out and receive just compensation. But obviously it's reared its head in a bunch of different ways that has made it fun to discuss, but also has made it a nightmare for athletic programs, agents, athletes, and unfortunately now we're seeing potentially even the U.S. government.
Yeah, and to give people a little bit of your background just quickly, and if I miss anything here, let me know. But I think you offer a unique perspective on this as somebody who played college football, won a national championship. Shout out to the football and the game-worn cleats behind me at FSU. You've had experience as an agent, and now as an attorney. Kind of really I guess you haven't sat in Congress yet, so maybe we need to add a fourth piece to this pie, but do have good perspective on a lot of different angles on this, not just one side. You've kind of, not that you lived the NIL world as an athlete, but you did live the student athlete portion of it, and you've lived the agent portion, and now in an attorney role. I think you provide some good perspective, which, again, I appreciate you taking the time to join us today. Just big picture, I think a lot of people will understand kind of this question, but just so that we are kind of complete in talking about it, can you just talk to me before we get into the SCORE Act, which is kind of just dropped this week with Ross Dellinger reporting and some others, just the big components of the House settlement and how the House settlement alone kind of changes the landscape financially of college athletes?
Yeah, absolutely. So the House settlement, honestly, was something that I wasn't sure was actually going to get signed and approved and ultimately ordered by the judge. And, I know a lot of other legal pundits, such as Darren Heitner, someone who has a strong hold in the NIL space, not just in Florida, but from a national news coverage perspective. I know he had skepticism around it too. But ultimately, when the House settlement ultimately was entered and approved by the judge, I would say some of the top things that I noted, prior to us hopping here today was obviously the revenue sharing with the athletes, right? Which now schools are going to be allowed to directly provide monetary compensation to student athletes in the range of about $20 to $25 million per year. Now, love that, right? We absolutely love that. We want our student athletes to be able to get compensated. Obviously, with that is some of the Title IX scrutiny, though, right? Both of us are Knowles. We understand how great college women's sports are across the country, but especially at Florida State, we've had so many national championships with softball, so many national championships with soccer. We are at the forefront in women collegiate sports. So one of the beautiful things that the House settlement did was also ensure that schools must have revenue sharing compliance with Title IX, which basically means that all of the women athletes must receive proportional benefits, right? That's the key word there, proportional benefits. And I know as soon as the House settlement went into effect, I heard and saw online that a lot of challenges and appeals were filed in regards to Title IX from some of these women athletes. Ultimately, too, we're going to see a back pay compensation for former athletes. I believe the number was 2.7 billion in back pay over 10 years to former athletes dating back to 2016. And ultimately, again, this allows compensation to be provided to athletes who were previously NCAA, stars, NCAA athletes who had not had the opportunity to profit from NIL prior to those rules being changed in 2020 and 2021. Now, again, this is one of those areas where I love it, right? I love that they're going back and trying to make right those years of what's now perceived as wrongdoing, somewhat of perceived as predatory practices against these student athletes, where the university, the conference, the NCAA was able to rake in money without having to pay any of the actual athletes who were generating this money. But again, with that, we already saw a lot of lawsuits, right? So why now? And we've also saw appeals to the House settlement in this regard as well, because why is it capped at 2.7? Why is it capped at only going back 10 years, right? What about individuals like Reggie Bush, who played prior to 10 years ago? I know he filed some individual lawsuits on his own, separate and apart from being a member of the House settlement class, right? So again, love that the back pay compensation came in. Love that they're doing the revenue sharing with athletes. There's also going to be caps on some of these future NIL collectives with that, which again, I do think is important. And I know we're going to talk about it a little bit more afterwards. But ultimately, the collectives were something that kind of grew out of this area that I don't think was necessarily intended and wasn't necessarily expected, because I think when NIL first came into play, it was great to say, hey, this student athlete can go get a local pizza joint, a local bar, a local, Guthrie's, right? Well, I love Guthrie's, a local food joint in that area to sponsor those student athletes, for a small amount of compensation. But what turned into it was these collectives throughout the country blossomed and then started paying these student athletes an amount of money that's sometimes more than what professionals are making, right? So having that cap, I do think is important. And again, I don't want it to sound like I'm in favor of the student athletes' rights being taken away, but we do need some constraints on everything. So the House settlement provides some of those constraints.
Looking at the House settlement specifically, and then we'll start to get into some of those constraints and the SCORE Act and things like that. Is this the first step to getting away from the amateurism model as we kind of know it?
I definitely think so, especially because they're now allowing the universities to do those rev share agreements and to have direct compensation going to these athletes. Because really, that is what makes somebody a professional athlete, right? Or a professional singer or a professional anywhere, right? You're being paid for what you're doing, right? That's the definition of a professional. Now, I know that they are still trying to prohibit straight up pay for play. But again, it's really starting to blur those lines more so than ever, because now it's similar, right? I'm a Baltimore Ravens fan. The Baltimore Ravens would pay Ray Lewis to play football. Now you might have a school like Florida State or UF or University of Miami to pay a player directly. Now, again, they're couching it as rev share, but now these universities are able to pay the player to pretty much, yes, they're attending school, but to pretty much be there to play football. Right. So again, I really think it's starting to blur those lines. And even though amateurism has been challenged, dating back to the 70s, really, you're going to see now more so than ever, I think, more and more challenges and probably a more streamlined approach to try to unionize and truly look at these athletes as employees.
Yeah, it is such a, I don't know if cop out's the right word or not, but yeah, they're saying it's based on their name, image, and likeness, and they got to do appearances and media stuff. But nobody would care about XYZ athlete doing an appearance if they weren't also the star of the football team, right? Like it's such
Right.
a, it sounds good. No, it's just because we're capitalizing on who they are as a person. Well, but would Jameis Winston have a line out the door, maybe for his personality interviews? Maybe he's not a good example, but like, would he have a line out the door to get autographs if he wasn't, a Heisman Trophy winning national champion, right? Like, if he was
Exactly.
just another student, if he was just another 6'5" guy going to class at Florida State, maybe because he's funny, but like outside of that, I don't know that people would care. And the same for anybody, DJ Lagway or Carson Beck or Cam Ward or any of these guys. Yeah, I mean, they might be cool people, but nobody would care if they weren't the star of that football team. And so I do think it's it's an easy cop out, right? To say like, well, it's not really to pay for play, but we all understand. And anybody with any kind of logic can say like, no, man, they're there to play football, right? Like that's
100%.
that's why people care. Nobody's outside of their classrooms cheering while they take a test.
Exactly.
The SCORE Act was introduced this week. Representative Gus Bilirakis aimed to codify parts of the House settlement. What are the highlights maybe from the SCORE Act, and do you see them aligning, conflicting with the original House settlement?
I think it does both, right? I think there's both alignments and conflicts. And I think even separate and apart from just alignments and conflicts, I think it starts to rear more issues that now will open up opportunities for additional litigation, right? Because really what they're trying to do here is limit some of the transfer chaos that we've seen over these years, right? They're trying to propose a federal NIL registry or clearinghouse to review these deals. They're still trying to preserve amateur status, right? They want more transparency between these NIL contracts and the schools and the collectives. They want to require agents and companies to be registered and certified, which I love, right? That's fantastic. They're still trying to ban a direct pay for play. And overall, they're trying to have a central federal government entity that's overseeing and controlling everything. And what they're also trying to do is really preempt any of these state laws that we've kind of seen come and go over the last 5 years, right? Anytime I was trying to have a conversation about this, whether it was speaking for a Florida bar event or scheduling, one of my recorded classes for the class I created at the FSU Law Stoops Business Center, uh, by the time that would air, or by the time I would get up there to speak, there would be a new state law amendment or change, right? So I do like the fact that we are going to hopefully have some type of mandated guidelines that covers this as an issue as a whole. Now, whether or not it's legal, right? You and I were talking about that before we got on. Whether or not it's legal for the federal government to step into this role, I think there's going to be a lot of litigation about that, right? I think that whenever you have the federal government stepping into the states, right, and trying to enact laws and regulatory actions on states, that is not something that had historically been given to the federal government, right? We always talk about the Bill of Rights, right? And what the federal government is supposed to be doing and what the states have the ability to do. And so while I've always been, someone who looks at themselves as a constitutionalist, who enjoys and appreciates the idea that, okay, if it's not something that the federal government has a power to do, then yes, each state should have their ability to work within the thresholds. And then if someone doesn't want to play in that state, if someone doesn't like that state, if someone doesn't want to live in that state, they have the ability to move from state to state. But here, I do like some type of central governing body or some type of central set of rules that all these states can follow, that all these agents can follow, that all these players can follow. Because when you have athletes who maybe are in high school in Florida, but then are being recruited by colleges in California, and then after they go there, after 1 year, they're going to transfer to Oregon, and then after that, they're going to transfer to Boston College. Now you're looking at 4 or 5 states' NIL laws. You're looking at 4 or 5 different schools' particular NIL rules, right? So for the last 5 years, when I've spoken with players, when I've spoken with agents, there's just been so much stress about, okay, which law controls right now, which rule controls right now. And that's where someone like me in that sports and entertainment legal field comes in to try and help these athletes, help these agents, and preserve their athletic eligibility, but also make sure that the institutions aren't going to be finding themselves in hot water either.
On the SCORE Act specifically, you talked about it, trying to preempt state laws. And we talked about this off air, but, we understand that college football is, the off season right now, which used to be kind of a dead time, right? You just focused on recruiting and that was it. Now the off season seems to have more drama than the actual 12 weeks of the season. But it is chaos right now, right? Like I think anybody can understand that. Even if you want if there's like three positions, right? Like I'm all on the side of the players and I want what's best for players. I don't care about anything else. And then there's the side of like, man, I just want college football to look like it did in like 2010 where, man, I just worry about the 12 guy. I don't have to worry about this drama and portal and NIL and all this other stuff. And then there's some people in the middle that are like, man, there's some good with NIL. There's some bad with NIL. I think that's where most people fall. But I think everybody would understand that, man, this is chaos right now. And so the SCORE Act, it feels like it's trying to reel in a lot of that chaos from hard caps that make it, where you can't pay outside of the NIL. It kind of maybe does away with some of the collective stuff that we've got going on. Limiting transfers to a one-time, which, to me, I can hear those things. I can say maybe that's good for college football to reel in some of the craziness. But you talked about, we've talked about antitrust and we've talked about state laws. And, even though it seems like the SCORE Act is looking to clean up the sport some, I don't know that it falls in line. And, you talked about the Constitution and what the federal government can do compared to state laws and stuff like that. I don't know that it falls in line with what is necessarily right or what is necessarily like constitutional. And I do think that we are going to see whether it passes or not is a different question. Getting Congress to agree on things is, typically pretty tough. But man, I can see some of these Texas senators saying, no, I'm not doing that. I'm not agreeing to something that hurts my universities. We've got money. Could I see Delaware saying, yeah, let's do this, right? Like, let's calm this down. Could I see, Massachusetts saying, yeah, we need, but I could certainly see Texas senators or Alabama senators, Georgia senators, California, Oregon saying, no, we're not putting these restrictions on. And so whether it passes or not is maybe one question. But then a second is, will it even hold up? And I have a hard time, layman here, not a legal expert by any means like you are, but I have a hard time seeing it hold up because of the laws in our country.
Absolutely. No, I think there's going to be a lot of challenges to it. And I think you hit the nail on the head, right? They're trying to curb some of this chaos. But whenever you are having, in my opinion, the federal government step in and try and control and limit what states and what state entities can do, there's going to be litigation, right? And it's always going to come down to who prevails, right? Because sometimes it's not even about who's right, right? I mean, we look back at previous court rulings where the NCAA prevailed, such as with Maurice Claret, right? But now we look back at that and we're like, well, yes, the NCAA prevailed, but based on these new laws, they weren't right. So I don't think we're going to ultimately get a determination of who's right or who's wrong. But I do think we're going to start to see litigation be filed, and ultimately, I do think we're going to figure out from judges ruling on these litigation who's going to prevail in the short term, right? And like we talked about before, sometimes that short term prevailing is just a Band-Aid. But, one of the things that I think is, and you just kind of spoke about it too, when you're stepping in to control the chaos as well, now it might push out these collectives, right? And now if you're trying to put these clearinghouses in play like NIL Go, where you have to submit and have, these contracts ultimately reviewed and approved, right? And we all have heard in the House settlement where Deloitte is going to be looking and approving or, denying approval for these different NIL contracts. But, and I know Darren Heitner talks about it sometimes too, but, at that point, right, if a school has promised a student athlete, let's just say $1 million, and then that deal gets struck down, does that now put us back into a position where now schools might want to pay that $1 million or these collectives or these third parties, does that now put them back into a position where now they're being asked or being forced or being put in the precarious situation of, hey, do we still make this payment unlawfully, right? And again, I'm not accusing any schools of doing that, but we've always heard these stories of the early 2000s, of the 90s, of money being paid to players, improperly under the table, whether it's by agents, schools, boosters, right? And so does now more oversight, more restrictions now almost push us back to the point where there was more of a promotion of improper benefits being paid. And to me, that's the last thing I want, right? So at the end of the day, while I want a restriction on the chaos that's been ensuing, I don't want those restrictions, whether at the federal level, state level, or even at an institution level, to then cause or entice, maybe entice is the better word, entice these collectives, entice these athletes and agents, entice these third party brand companies that you're entering into deals with to try and make these payments under the table to avoid these clearinghouse issues, to avoid any scrutiny by any of these governing bodies. So I think there needs to be a happy medium. And ultimately, to me, and we kind of talked about it before, and hopefully we'll be able to talk about it throughout the season as well, is I do just think at this point they need to label the student athletes as employees, and there needs to be a collective bargaining agreement. And maybe that comes from my days as an NFLPA certified contract advisor, right? Under the NFLPA umbrella, all the players are part of the NFLPA. So were we as agents, right? We had to pass an NFLPA certified contract advisor exam. We were capped at 3% of what we could then get off of those NFL contracts that the players sign with the teams. So, you have the SCORE Act coming in trying to restrict agents to 5%, right? But the SCORE Act isn't saying, hey, there's a mandated test that these individuals have to take. So to me, the collective bargaining, right, the unionization is not just going to help the players to have benefits such as healthcare, right, such as disability, but it's also going to protect and allow the players to have hopefully agents who have to go through an accreditation process. So then you're cleaning up the process. You're making it more straightforward. And then if there's violations, right, there's strict rules as an NFLPA certified contract advisor. And if we violate those, we can lose our license. We could then be faced with sanctions from the NCAA, right? So the more rules sometimes, yes, can cause, and I think what might happen now is cause or entice people to try and play outside those bounds. But to me, if there is a unionization here, if there is a collective bargaining agreement, if there is a direct process for who can be paid, how much they can be paid, and what percentage agents can get, I think those fundamental guidelines will help preserve not only the integrity of college sports, but also bring us back to a time where once a player is recruited, once a player steps foot on campus, you're excited to see them develop and then ultimately become a starter at that university.
Yeah. And I don't know if you have any thoughts just around that, right? Like so many people have very strong opinions on both sides of whether players should be made employees, if that's the right route to go. I'm in favor of that. I understand there's pros and cons with everything in life, and I understand there are some cons there too. It doesn't really seem like the schools want to do that at this point for a list of reasons, money probably being at the top of it. But it does feel like, and we talked about this off air, it feels like they're trying to dip their toe into some waters and really, straddle the fence, whatever cliche you want to use, while also standing on a banana peel. We'll just go real punny at the same time. But it does feel like, and I don't know if you want to guesstimate it, but do you feel like we're moving towards employment? Do you think schools will just hold off on that for as long as they possibly can? I wonder what it'll take, and I'm asking a lot of really open-ended questions here, but I just wonder what it'll take for us to eventually get to there, because to me, that feels like the proper fix. It feels like the SCORE Act is kind of if it passes and goes through and maybe even gets upheld at some point through up to the Supreme Court or something like that, it feels like that's still not necessarily the right way to fix a problem, right? I could have an infection on my hand and cut my arm off, and that fixes the problem, but it doesn't really it creates another problem. So does employment status, does that happen soon? Do you think that we are kind of on a pathway to that? Do we need to fail at a couple of things like the House settlement and the SCORE Act to eventually get there, or just thoughts around that? And we'll wrap up.
I don't think we're close, but I do think we're heading in that direction. I mean, I think O'Banion, if I remember correctly, really settled right around the time I was transitioning from being a collegiate athlete into going into law school, right? So that was about 2014. Um, so if we look back, right, from O'Banion to now, about 11 years. So now 11 years in the grand scheme of the world, 11 years in the grand scheme of sports, or in the grand scheme of litigation, maybe that isn't a long amount of time, but soon to me would mean, next couple seasons. I don't think we're going to be there in the next couple seasons. I do think it's going to take more litigation, more more issues, and not just litigation, right? But more problems where agents are being held accountable for some improper deal with a university or collective, where a student athlete loses their eligibility because of violating some of these new rules that have been established. And then the litigation that ensues from that, right? Or maybe it's even a coach. Maybe it is an entire program, right? I think it's going to take something pretty catastrophic and newsworthy to really push that over. But going from a legal perspective, right? We learn in law school, and then I practice it now. Whether or not you're an employee is substance over form, right? So it's not just what does the contract say. So many times, employers, right? In Florida, we're a very employer-friendly state. So a lot of times, employers will try and couch this person that they're hiring as a 1099 independent contractor, right? And that contract that this individual signs with the employer might say, I am an independent contractor. But again, it's substance over form. So the courts don't just look at what you sign. The courts look at different factors, such as, do they control what time you arrive and leave? Do you have a set schedule? Do you have set duties? And so the more and more that this employer is controlling your day-to-day activities, the more the court looks at you as an employee as opposed to a 1099 contractor, right? So let's translate that to the world of college sports. When I was playing, I had to be at 6 a.m. practice, right? I had to have all my classes basically in the morning, because then after that, I needed to get over to the facility, and I had to do sometimes some workouts or stretches or watch film before practice. Had to go to practice, maybe do a post workout, maybe watch more film, and then I have to worry about school, and then I got to do it again the next day, right? So, when I say worry about school, study for tests the next day and whatnot, and obviously certain players have access to different tutors right throughout that process. So if from the moment you wake up as a student athlete to the moment you go to sleep, you might be on campus using their facilities, whether it's for treatment, whether it's for training, whether it's for tutors, and you have set times when you need to watch film, set times on when you can work out, set times on when you can go to class. That starts to look more like they are acting as an employer and controlling your movements and what you can do and not do, as it does, just being a student, or as it would in the world of independent contractors, look like a 1099 independent contractor as opposed to an employee. And then when you start adding payments in, right? Payments. So if you're a 1099 contractor, right? Normally it might be a flat rate fee, or based on, you're going to get paid for this amount of work, right? But there's not necessarily an hourly rate that you're getting paid every day, or a salary that you're getting paid. Well, now we're looking at rev share, where you're being paid potentially throughout the course of the season, right? Now you're directly being compensated from these institutions. So again, I think we're starting to blur those lines more and more, just from a fundamental independent contractor employer standpoint. And I think the more we get to that, the more we're going to see and feel the need for the unionization and collective bargaining to have these individuals as employees.
Paul, I appreciate you for joining us today. We're going to talk a little bit about one of those specific challenges to the House settlement in our next segment. But before we go, tell people about Ruben Law, a little bit about where they can follow you and find some of the stuff that you've got going on, and then we'll get out of here.
Absolutely. Thank you, TJ. So Ruben and Ruben is a law firm that's been in Florida helping protect and serve the communities here in South Florida and throughout the state of Florida since the 1950s. The founder of the firm, Ellis Ruben, was a famous criminal defense attorney in Miami. And then his son, Guy Ruben, is here as my managing partner. Myself and Guy, we get along great. We love working together because we view ourselves as trial attorneys, right? There's some matters we won't take, but ultimately we want to be the people in the community that get called upon when there is an injustice, right? That injustice could be a civil rights violation. That injustice could be a false arrest. That injustice could be being hurt in a car accident and you're trying to get compensated fairly for that. And sometimes it's here in the world of sports and entertainment, right? So I myself represent agents. I've represented athletes. I've had to work between agents and athletes when there's disputes as to the payment of agent fees. I've represented athletes to appeal eligibility, right? And so last year we had a case where this individual literally played 3 innings over the threshold of his NCAA season as a baseball player before he got injured. And the conference said, hey, you're done. That's your season. So we appealed all the way up to the NCAA and they reversed that. And now that student athlete was able to transfer to a Division I program for his final season, right? So those injustices could be wrongful death, or they could simply be an athlete who's having a problem with eligibility, having a problem with their agent, or trying to navigate this chaotic world of NIL. And so we're here at Ruben and Ruben to help you all through those needs. And you can call us at 772-283-2004 or reach out to me on Instagram at Paul_Aloise, spelled Aloise, and we'll get you set up for an intake and talk to you about how we can help.
Awesome. Thanks, man. I appreciate you for joining us, buddy.
Of course, man. Good as always to see you, and go Noles.
Go Noles.